properly respond to a request for buyer agent compensation in California. In other words, how you're going to counter on a contract when you're actually licensed to do it. I'm an attorney and a broker, and I'm going to explain the difference between what realtors can do and what should be done. So let me change the format here a little bit. Should I do that? No, that really isn't it. We'll do this. Okay, so this is a California residential purchase agreement. If you come down to G3, well, first of all, this is where the price and terms would change right in there. So let's say you were going to counter $100,000 higher, wherever that was. And in G3, this is where you see the request for buyer agent compensation. Now, as an attorney, the first thing you're going to say is, how did this get into a contract by a realtor association that's supposed to be partly owned or representing my listing agent as well as a buyer's agent? And yet the listing agent isn't licensed to properly respond, doesn't have any forms, doesn't have an authorization in writing to do so. I mean, it's like, yeah, they did it for years, but that's when that money was their money. The listing agent went in and negotiated for 6%. So of course they could negotiate buyer agent commission. Of course, it didn't matter that they were, well, it did matter because they got sued for $1.66 billion, but they got sued. It wasn't the listing agent. But now we flipped it. It's not their money. It's now the buyers, and they're not doing anything to change all the risks. And yet here it is. This clause, G3, introduces or reintroduces, it should be gone, but it reintroduces the risks of steering, the risks of compromising the fiduciary duty of the buyer's agent, the risk of commission fixing, keeping prices high, of buyers being confused about who's actually paying for their commissions. Because the buyer's agents, they're being trained to say, oh, well, I know 3%, I know $30,000 on $1 million home is high, but don't worry, we'll get the seller to pay it. They are being told that on the net. So it's still there. The DOJ said this new way of doing things in their second memo to the court knows, look, they're like, the risks are still there. It's just they've been transferred to the seller. So what is this form doing there? Without them saying you got to have an attorney first, and you have to learn how to mitigate the rules according to the market variables at the time. Like, it's easy to sell your house and multiple offers are coming in. Do 100% mitigation. If this is the only offer you're going to see for 6 months, maybe tread a little carefully. Like, that's why they can't make the forms. First of all, the DOJ took forms away and told the California Association they can have no forms related to buyer agent compensation from the reports in the media. But I can tell you from my reports, the listing agent has no authorization, no proper forms to counter. Let's take a look at what their counter looks like. They have no mitigation measures, and they're not telling their clients to talk to an attorney. I don't get it. But this is my words, right? This is a counteroffer. It's mostly, it's useful. I wouldn't call it entirely boilerplate like I did in the other video. I mean, it's useful, but it does nothing to do. It has nothing to do with buyer agent compensation. This is where a realtor is expected, and I've done a long video on this. If you look at the SIPR case and our training, realtors aren't even allowed to cross out forms. According to my broker training, realtors may not even cross out a word in a form. They're not licensed to do it. So can you imagine, like, this third-party beneficiary? Where is the G3 again? This is a third-party beneficiary clause. Seller agrees to pay buyer's broker out of transaction proceeds 2.5%, 3% of the final purchase price. And if applicable, well, that's really that first line. So it's seller payment to compensate buyer's broker. This is unquestionably a third-party beneficiary clause because it used to say, and the buyer has agreed to pay them. Now that's sort of implicit. Every listing agent knows it. Everyone knows the rule. If the buyer is working with a realtor, the realtor had to get their compensation term agreed to in writing from that buyer. So if there's a buyer's realtor and they saw your home, you know they're under contract. So this is a third-party beneficiary clause, and they're asking the seller to pay someone else's agent. Now, as an attorney, can you think of all the authorizations and the waivers that you would be required to feel comfortable before you were paying your defense attorney and you're paying the plaintiff's attorney? This is the seller trying to get the most. That's the buyer trying to pay the least. All the other terms involved, we're already, because we're paying the buyer's agent, we're already risk of steerings built into these forms. What if you don't pay it? They're going to walk. Compromise the fiduciary duty. This is that. It's right there. Additionally, as if they pay a percentage based, now they're incentivizing that agent to get more money if they get their person to pay more. That's DOJ brought it up. It's already in there. Okay. So now understanding that, now let's get to the counter. Here's the counter. This is just words. I mean, this is a choice that it's a legal choice. There's many other ways to do this. Box G3 is hereby unchecked. To me, that's very important. We don't want to tie in the buyer agent compensation to the price and terms of the home. That's really harmful to the seller, yet that's the only thing an agent can do. Ignore it or write that term in here. We want separate negotiations. We want the price and terms of the home. We want that to be friendly and we proceed and it's all good. And then later we want to deal with the buyer's agent compensation. So we're unchecking that box. So it's not part of this anymore. So they're going to have to introduce it round after round. We don't want to just be a term that's already locked in and then move on to buyer agent compensation like a lot of realtors do. We want to keep it in the air. We want that realtor sweating, working to get this deal done, understanding that if they get it done quickly, closer to the agent's terms, there's a better chance they're going to get paid or get paid fully. And yes, that's built in, right? That's why you have to have these waivers. It's built in, that calculus. The only thing that's not built in is like just automatically agreeing and leaving it out. And now that's a listing agent sticking their seller with liability and not warning them they can mitigate it or get an attorney and easily mitigate it. If you're paying full buyer agent compensation, you could have that buyer's agent and buyer jump through all the hoops, acknowledging where the money's coming from, the source of the funds, waiving lawsuits and all sorts of other things that you can protect. I'm not saying they'll all hold up in court, but you can mitigate substantially. You could go from full mitigation to substantial mitigation if you're paying buyer agent compensation. And if your agent doesn't bring that up and doesn't counter, I mean, what are they doing, right? So box G3 is hereby unchecked. Any request for compensation of buyer's broker must be made in a separate written agreement between buyer and seller is not a term of this purchase agreement. Now, since you're an attorney, in that second agreement, you would have the mitigation measures that after counseling the seller and getting the market temperature and how risk averse they are, you'd put those into that separate agreement. So each round, you'd hope that they submitted a request for buyer agent compensation with an acknowledgement that the source of the funds is the buyer, is the buyer's money, and the buyer acknowledges that they could be seeking a price reduction, but instead, as a convenience to the buyer, they're asking the seller to pay buyer agent commissions. Like, I think that would be a good start. There's many other measures. So, but you've got that second one built in. It also improves the transaction's negotiation ability. I've talked about that in other videos. And then you can do price in terms of the home here if you'd like. That's just one way. Myriad ways to do it. I mean, you could say, well, you could say, so here, rather than making my basic one saying they've got to come up with the form, you could say, and the form is attached, or the form is submitted in an email to the listing agent. You could say, this is my preferred way of doing it, saying, go to 1234 Mockingbird Lane and get the buyer agent compensation request form. Have the buyer sign it, and boom. Now, if your seller's really risk averse, you'd have them say, you'd have a little buyer education there, whether by words or by a short video. You could say, then have the AI ask a question. So when you're ready, submit the address of the property and your email or your phone number, and our AI will send it to you. And the AI could say, are you aware? I mean, like I have a go high level. I could share that if attorneys are interested. I have a go high level website that is set up to do those that exact things. Like you could have it your client's website address. You could say certified buyer. I don't know that I'd be sending to my law firm, but that might be a good idea. You could say, look, I'm a lawyer. I'm working for the seller. The seller has sent you here because I've advised them that there's liability. But the seller's also, as a convenience too, willing to pay your agent. They just want you to understand a few things and then waive your rights with respect to them, because really they'd rather not pay your agent, but they're doing it as a convenience to you. And you can now mitigate substantially that seller's risk and help them sell their home for more. Realtors can't do any of that. So that would be how I would consider doing my counters.